Hey guys, we have a quick live because there is some footage from Court TV of the Antonio Brown status hearing. So this was this morning. Today is January 27th. We are in 2026. And this status hearing, the current issue on hand is the defense has a pending motion to dismiss on the grounds of immunity from prosecution under Florida Stand Your Law. I did a video reading that full motion to dismiss. It's linked in the description. And we'll do a quick summary of it where it's relevant. But this hearing is just to do a check. Is everything moving on track? Are all of our dates good? Are there any issues? So let's take a listen and see what's going on.
Your Honor, on behalf of the state for Mr. Antonio Brown.
Yes, ma'am. Mr. Brown's case.
Good morning, Your Honor. Mark Eiglarsh on behalf of Mr. Brown, who's present on Zoom.
Okay. Yes, I see Mr. Brown is there and present. All right. We have today.
Your Honor, as my understanding, we are set to pick a date for the stand your ground motion that was filed.
Yes.
That wasn't my understanding. We're going to be taking some depositions before that time, Judge. And I also want to get the DNA evidence that's outstanding. My client voluntarily submitted a swab recently. And if the test goes the way that we expect, we believe that that's going to undermine a significant allegation the state made. So we're wondering when we can expect that DNA evidence.
Well, let me back up. Actually, today was a date that I was going to be addressing the setting of, you filed the stand your ground motion.
Right.
And I believe from the last proceeding, I said I'd like to set a date for that.
Correct.
Now, you have other matters and discovery issues. You should be dealing with that. So let me give you a date for the stand your ground hearing.
The reason why I wanted to delay in doing that is there's some depositions I'd like to take before we have that hearing.
Okay.
And I want to get all the evidence before I take those depositions. So it comes back to when are we going to get the DNA evidence?
All right. Well, that's your question. And state, you have a response?
No, Your Honor, I'm not sure. I know that we did receive a DNA result. Is my understanding that was provided to the defense counsel, so I'm not quite sure exactly.
Look at his face here. Look at Mark Eiglarsh's face here.
Result is my understanding that was provided to the defense counsel, so I'm not quite sure exactly which DNA result he's looking for. Maybe if he can send me an email, I can provide whatever it is. It seems to be missing.
Counsel outline and communicate directly with the state of what information you're still missing in discovery. And
The state is claiming that the swab that was taken in my office, in my presence with the agents, just a couple of weeks ago, that somehow that made it to the lab and that there's results on that, and we have been supplied that result. Is that what the state's alleging?
Judge, that's my understanding. I can double check. I know that I was in trial and the second ASA on the case was handling the discovery, but that's what my understanding is. I can double check.
the second ASA on the,
It was Miss Stephanie Cruz.
okay.
He was present in front of Your Honor the last time the case was set for status.
And she needs to speak with you about things. So she didn't really have the responses either. So between the two of you, I'd like some responses.
Absolutely, Judge. I can look into the DNA that the defense counsel is asking. I did receive an email from him yesterday requesting deposition dates. I provided dates towards the end of February, beginning of March for
So 30 days
depositions.
away.
But that's all it was asked of me at that time.
Okay, so this is what you'll need to do, Mr. Eiglarsh. I'm going to give the state 5 days to
They better hope, Felicia better hope that Stephanie Cruz, her fellow ASA, because in Florida we do state attorneys instead of district attorney monikers. She better hope that they have these results because the judge is like, all right, you have 5 days. You have 5 days.
respond to the DNA question that you raised in terms of any a bit of discovery that seems to be outstanding.
Sure, Judge.
I can be even more specific, Judge. It was the holster left on the scene that we have submitted proof belonged to my client. That was his own holster from his own weapon for which he has a concealed weapons permit. And they went
Mr.
and DNA.
Eiglash,
Yeah,
Mr. Eiglash, I absolutely understand.
got it.
As in terms of what the specifics are, there's outstanding discovery on the response specifically on the results of DNA testing, right? I'm giving the state 5 days
Perfect. Thank you.
to respond and advise where the results are. And if they haven't been provided, then you'll file an appropriate motion that you think you need to file, and I'll address the motion,
Will do.
okay? I'll take care of that. The next thing is setting your deposition schedule. And I hear from the state that you've been provided with some dates
Right.
to go ahead and set your deposition schedule. And so what I would ask, barring having to address any motions that either party might file, I'm going to give you one more status date. And at the next status date, I'd like you to come in, if you would please, with some type of schedule of your depositions, that you at least set your scheduled depositions, because you just indicated you need to take a number of depositions before you can be prepared for the stand your ground motion hearing that I'd like to set. So I'd like to
And I would
keep
like
that
to
moving
watch.
along, and as well handle any other discovery questions. So I'm suggesting the end of February. Unless, of course, either of you need me sooner, then you'll file a motion and I'll address it. All you have to do is contact my office. It gets on the next day.
Thanks, Judge. The end of February works for the state judge, for another status date.
Okay. Does it work for you, Mr. Eiglash?
Yeah, it depends what date, but yes, Judge, absolutely. Yeah.
Well, February 26th seems to be my date of choice today. So will that work for you?
I have a 9 o'clock in front of another judge, but I'd rather do it on a day that I don't have that, and I have an injunction hearing at 1:30. Could the court do it on the 25th? Or
We can do it on the 25th. That's fine.
that would be
Can we
ideal.
make- Fine. We'll manage it for the 25th at 9 a.m.
All right, we'll see you then, Judge. Thank you so much.
Okay, very good. Thank you.
Have a wonderful day.
right,
Thank you
so
very
You
then
much.
it
too.
wraps
Thank
up.
you.
Appreciate it.
All right.
So on first impression, I'm like, is this just like a super Florida thing where we seem to have these cases where everything looks so crazy? I'm thinking of the Courtney Clenny case. And then we mess up on basic questions, basic discovery. In the Courtney Clenny case, we don't employ proper filters, and the state's sitting there nosing through attorney-client privilege communications. Is this another instance? Because it just seems like, how have you not responded to this? And then how do you not know if you actually have the DNA test results or not? I get it, you have an extra colleague that you can tag team these cases with, but it's the same thing that I feel like I've heard over and over in the Courtney Clenny case, where, hey, I'm not sure what my colleague was doing, or that was my colleague, so don't hold it against the rest of us. Well, I'm trying to think as we go through this, from what's been filed in this case so far. Very quickly, Mark Eiglash had filed a copy of Antonio Brown's concealed weapon or firearm license. And then they filed a motion to dismiss, again, for immunity from prosecution under Florida Stand Your Ground law. And when I read that, I was really shocked. And it kind of made sense why the bond in this case was only set for 25 grand. So you have a celebrity with a lot of money. It seems like, Antonio Brown, he's crazy. Maybe he's got CTE. Something's going on with that guy. Now we hear that he's shooting at somebody and then he's out of the country. You would think it should be a slam dunk. But then his bond amount's only 25 grand. And I read this motion to dismiss, and of course a motion to dismiss is going to be the defense's perspective of things, right? It's going to be written from their perspective. They're going to be discussing some facts that are in dispute that the state disagrees with. But some of what I read in here was just, I never knew. I thought it was really shocking. So at first it starts off by detailing that the alleged victim in this case, there's several incidents where there's been physical and verbal threats originating from the alleged victim in this case. And I read the full thing. The link is in the description if you want to go through the full motion. But they detail some of that here. And the date in question where this alleged attempted murder happened, May 16th, 2025, Antonio Brown was at one of Aiden Ross's boxing events. So, after already having a series of run-ins, if you will, with the same alleged victim, Nantambu, on this May 16th, 2025 evening, Nantambu knew this again. This is the defense's motion, so it's their arguments. Nantambu knew that Brown was attending the celebrity boxing event because Brown had been publicly live streaming from the venue. Video evidence shows Nantambu waiting outside the event, despite not being invited, for an opportunity to confront Brown violently. And of course, the state's going to say it was an event that members of the public could go to. I haven't seen their response, but I'm sure that's what they'll argue. As Brown exited the event and walked through the parking garage, he observed Nantambu quickly and deliberately approaching. From his manner of approach, including tucking his chain inside his shirt, and based on Nantambu's disturbing history, I also learned reading this motion to dismiss, he, was running around with a flag during a Super Bowl halftime show. It's the same guy. I guess he's known. He's well known. But he's tucking his chain, he's standing outside this event, and Brown is on alert. Nantambu unlawfully attacked Brown, and others on the scene joined in the assault. Brown sustained an injury to his eye, knee, and hands, leaving him with visible bleeding. The chaos created by Nantambu's violent attack heightened Brown's fear for his life. He reasonably believed that Nantambu, his associates, or others on the scene intended to inflict further harm. Brown's sole focus in that moment was to flee to safety by reaching his rental car, which was parked nearby on the street. Now, when I was reading this, the videos that I'd seen going around online, I think I have my order of operations backwards, and maybe half the internet does as well. Either that or this write-up is incorrect. I don't know. Fearing additional violence and believing he may encounter Nantambu again while attempting to reach his vehicle, Brown retrieved his concealed firearm, for which he lawfully possessed a permit. So Brown quickly began to run from the parking garage to his vehicle in an effort to reach safely as swiftly as possible. So my understanding when I first saw the video clips come out, I thought he went to his car and then came back with his security's gun or something. Apparently he didn't make it to his vehicle, according to this. They say here that the state's assertion that Brown was running with the intent to shoot the alleged victim is incorrect. As anticipated, Brown again encountered Nantambu. Nantambu, who was waiting near the entrance of the parking garage. Immediately upon seeing Brown, Nantambu, whom Brown reasonably feared was armed, made an aggressive movement towards him, demonstrating an intent to cause further harm. In that moment, Brown again reasonably feared death or great bodily harm. In response, he fired 2 warning shots, intentionally aiming away from Nantambu to ensure he would not be struck. Now, warning shots aren't just easy peasy, no harm, no foul. Warning shots can be very dangerous too. But he is saying that, hey, I made the decision to fire warning shots. It was not an intent to actually even shoot in the alleged victim's direction. Brown hoped the warning shots would deter Nantambu's aggression, allowing Brown to safely reach his vehicle and leave the scene. Nantambu then initiated a physical struggle with Brown, and this is the critical part where we have this issue and why the DNA is so important. Nantambu then initiated a physical struggle with Brown, during which he forcibly took Brown's firearm. Nantambu, a convicted felon, fled the scene with the weapon, meaning he's not supposed to have a weapon. So he fled the scene with the weapon, thereby committing the serious offense of possession of a firearm by a convicted felon in violation of Florida statute section 790.23. Here, Brown did not flee. Instead, he remained at the scene and complied with law enforcement. I believe some of and maybe there will be additional notices here, but there are already some disclosure of what seems to be 3 different law enforcement officers. Maybe at least one of these is one of the individuals who was here with Brown at the scene. And the issue here, it's starting to make sense to me. The defense quickly has, Antonio Brown gives a swab of his DNA. I think they're going to try to say that there's other DNA on the recovered firearm, and maybe that DNA belongs to Nantambu, who's not supposed to have a firearm, and that firearm is legally registered to Brown. So if there is, in fact, Nantambu's DNA, he flees the scene, it would look like the order of events as being told by Antonio Brown here is credible. It would corroborate this version of the facts as being stated by Antonio Brown. Brown, however, did not flee. He remained at the scene. He complied with law enforcement. After conducting an on-scene investigation, City of Miami police officers released Brown from the scene without charging him with any criminal offenses. Then, while Nantambu initially claimed to police that one of Brown's bullets possibly grazed him on the neck, he later admitted in a publicly aired interview, including with TMZ, that the mark on his neck was actually the result of Brown scratching him during the physical altercation before any shots were fired. So again, it's two incidents, and my current perspective on what it seems like the order of operations is very different than when I just saw the videos online. I thought there was maybe like some yelling, some arguing. We go to the car, we retrieve a firearm, and instead of just getting in the car and leaving, we come back and cause chaos, which doesn't seem reasonable. But now I have questions. I have questions. And I can't help but think about how this bond was only set for 25 grand. So, yeah. So I don't know. And then they finish here. There's one more line, so let's just read it. Additionally, Nantambu has publicly issued threats towards Brown, including statements such as, "Your days are numbered," and that's in quotes. So again, the full motion, link in the description if you want to check out, everything we skipped through with a summary. And then, I'm going to be following this. I wasn't really all that interested. I don't know, it just seems like something's odd about it. So I'm looking forward to, anything happens between now and when we actually have the hearing for the arguments on the motion to dismiss the stand your ground. I'll post an update. But I want to watch that stand your ground hearing. I think that's going to be really interesting. So there is that, you guys. That was a quick update. Again, that clip of the hearing, I think, was like 5 or 6 minutes. 6 minutes, 17 seconds. But I thought it was an interesting question. And where's the DNA results? Send them our way, because we want them. The defense wants the DNA. They want to see, who this holster belonged to. Maybe there's going to be an issue with this missing firearm. Right? So, if they never retrieved the firearm, if, quote-unquote, Nantambu ran away with it, and they never recovered the firearm, the best thing that Antonio Brown could say would be, "Hey, my firearm is missing, and he took it." And then it's, he said, she said. But if there was a holster recovered at the scene, and his DNA is on it, that could help go to show that I, Antonio Brown, did in fact have a firearm. I didn't try to make it disappear on you. I waited and spoke with law enforcement, and they did not find the firearm on me at that time. But I'm telling you that this other guy who's claiming he's the victim took this firearm and ran away, even though he was staking out outside the venue to find me. So it seems really messy. It just seems really, really, really messy. But all in all, you know what? I've already changed some of my opinion. I reserve the right. I will happily change my opinion as we learn more. Interested in what you guys think. I see Credence and Mikey says stopping by to hit the like. Shout out to Mikey over at Credence and Mikey. Probably the best at uploading crazy body cam footage and having good watch parties over there. So make sure you check him out. We've got Mel in the building. Chelsea, good to see you. I feel like it's been a while. Tim is in the building. Says, I watched this boxing event live on Aiden Ross's Kick stream, and what happened was after the boxing event was over, the guy tried to snatch AB's chain, and then that is when the rest happened. And I think that's going to be interesting. Like, if this goes to trial, can we get into prior incidents? I have an issue when prior bad acts come in and they're just like, oh, someone did something nasty one time, but it's not really related to the type of behavior that this person's on trial for now. Or bad character evidence about a witness, potential bias. And I don't see how the state will keep out some of this these prior actions of Nantambu particularly there was a civil lawsuit already. So I don't see how civil litigation that Nantambu initiated against Antonio Brown could be kept out, right? He's a complaining witness. I don't see how the state could put this case on and have a strong case at all if Nantambu doesn't take the stand. But if he takes a stand, then I think Antonio Brown's team has every right to ask him about, well, haven't you sued him? Like, over jewelry issues? So, because it goes to bias. And as a criminal defendant, you have the right to confront your witnesses. So, it's a lot. I think this is just going to be one of those cases that's just like a hot mess. A hot mess. And I don't know, I have a great track record, I think, of, well, this case doesn't seem too interesting, but wait, maybe. And then all of a sudden, it's just chaos. So we'll see. We've got Gina in the building. That's okay. Don't worry that you're late. This is a short one, you guys, because again, the hearing was really short. Gwennon with the kind reminder to hit that like button, leave your DNA on the subscribe button, plant a like. Yeah, plant a like. Plant a like. Love it. And Gwennon, I know you're taking a trip soon, so safe travels and please enjoy your trip. Let's see. Yes, Mel says bullets don't have eyes, so sending warning shots not good. What goes up must come down. So, there's a Florida, I don't know exactly where it happened, but I think it was close enough to me that it just came through like a local news feed. And some guy, well, let me start with how it was found. Some woman realized that it's not fireworks on New Year's Eve, that there's actually shots being fired. And I think 2 or 3 bullets, like, go through her home. And it turns out a neighbor, his story is he was just celebrating when the clock struck midnight for New Year's. And was just blasting. It's like, it's midnight, I'm going to start blasting. I'm celebrating. That's his story. And bullets are somehow going through this woman's home who lived in a home nearby where this guy lived. Florida man, Florida story. So, whether that's really what he was doing, because it doesn't seem like he was just firing up in the air to celebrate and didn't realize why that's a stupid idea. It seems like the trajectory was like horizontal, like parallel to the ground. But that was his story. That was his story. Very, very Florida story. And luckily, she's okay. As far as I knew, it wasn't reported that anybody was struck or hurt, thank goodness. So, Keisha says we back. Yes, for just a little get-together here. And not for nothing. I like the idea, like, if we can watch Zoom court, I liked being able to see all 3 of their faces at the same time and just watch their facial expressions. I mean, Antonio Brown didn't really move. He was just kind of stoically sitting there most of the time. like he moves a little bit. But the judge, I think, is animated. This is Judge Marisa Tinkler Mendez. And Mark is, I think, somewhat animated. So, with that being said, thank you for tuning in, everybody. We had the World's End popping in here. Thank you for being a member for 16 months. It's great to see you right back. Angela says, Antonio Brown needs to be seen by a specialist. He's not right in the head. That might be the case, but I still think this is messy. And I think my initial judgment on this case stemmed from, preconceived judgments that I hold about Antonio Brown and his antics, if you will. So, yeah, now he's a stern poker face. Stern poker face. So, let's see. Sheriff Chuck says, Gwennon, enjoy your trip. I'll narrate what you missed. Love the community effort here. Love to see it. Guys, I have this stream set up to redirect over to Take It to Trial, who's doing the Paul Canero case. So, yesterday when I tried to set up a redirect to her, she ended before I ended. So, we've only been here 24 minutes. I hope she's still going. I'm going to hit the end stream and carry us over there. We're going to travel over to Take It to Trial. If you don't already know, you might hear me call her Sweet Pea. So, that's her name. Her channel is Take It to Trial. If you don't already know her, you should. Streams a ton of trials, and she lives up to her name. So, hope you'll hit the subscribe when you get over there if you don't already follow her. And see you next time, wherever I see you guys. Bye, guys.